Thank you. Good morning. Talking about resources, I think we owe Michael Curry, and I know this won't be the last time we thank the National Constitution Center, but I think while he's still in the room, he deserves fantastic. I had no idea. It's not just the facilities, but the resources, the knowledge that these people have, as you do, collectively amazing. So from the most formidable of resources, those of you who have your red bags, if you haven't looked at them, I want you to know the kind of resources that we have for you. If you don't know that shortly after ABOTA invented the internet, we created these things. I'd never seen them before. If you don't know, you can erase your highlighters. And who among us has not highlighted something and go, oh, that's the wrong line? You can erase your mistakes and no one will know it. So our scientists are working in R&D on other things. We don't know what we're going to invent yet, the next thing, but our pens are very good. And you do have a constitution that, if I'm not saying you got to be Khazir Khan and you could do it in your classroom, but you might want to offer this constitution to somebody who needs it. So these resources are also available to you. This is going to sound a little weird, Larry Wilburn-ish. We're going to keep it 100 here for 1 second. So who out here, I want to show of hands, had a dream about John Dunlap or was in the Revolutionary period last night? I'm not asking for any prurient details or anything, but come on, nobody? Nobody dreamed of Dunlap or Jefferson? You guys. Well, I didn't either, so. Okay. Do we have any parliamentary procedure buffs here? Because if we don't, I'm going to take a brief moment of personal privilege and tell you this before I introduce our next speaker. Our daughter Kate and my wife Linda are coming over in a little bit. She's coming from Jersey City and won't get to see Sarah, but she's here to see Erwin Chemerinsky. To talk about parental pride, I'm not going to bore you with that. I have so much respect for our daughter. She is a person who has intellectual curiosity, very literate, passionate, and she has courage. And my wife made her, and you guys helped. And it would be, you would do me the privilege, if you see her, to introduce yourself to her. She's the product of all that you put in. Erwin Chemerinsky is one of the most fantastic speakers I've ever heard. And that's my way of saying, Sarah, good luck. Your next speaker, Sara Leon, I'd like to say she needs no introduction, but I can't. Sarah and I go back to the foundings of this program. There are foot soldiers, infantry, and then there are generals. Chemerinsky, folks like Louis Sifford, I'm going to say they're generals. Me, I'm probably at the front line. And so is Sarah. When we started this program in 2009, I didn't have people saying, I want to be a speaker. And Sarah was a speaker, presenter, not just year one, but in 2010, 2011, 2012, and 2013. I didn't have to beg her. Some I did have to beg. I didn't have to beg her. And I will tell you that among estimable speakers, she was always top-ranked because of what she provided in the way, her presentation and her engagement. We're going to clump you guys again, I think. It's really my privilege to say that through the Teachers Law School, I consider Sara Leon not only a soldier with me, but a friend. Please welcome Sara Leon.
Well, that's a lot of pressure. I didn't know I could say no all those times that I said yes. I just thought it was a given. So, welcome. I wanted to thank the National Constitution Society and ABOTA. This has just been an amazing conference. I hope you teachers have been enjoying this. I've really learned a lot and have been enjoying it. And My practice is representing school districts. I practice in the state of Texas. I've had the privilege of working with educators for the last 26 years now. And what I've learned is if there's any place mischief can occur, it's probably in a school or a classroom. And so I learn from your experiences every day, and it's really just my privilege to support what you do and respect what you do. You all have the most important job in the world as far as I'm concerned, and to the extent we can support you, it's our privilege to do it. I started this presentation the first teacher's law school. David asked me to fill in for someone else who didn't want to speak. And the question was, what do you want me to talk about? And so I decided to present kind of what does an attorney actually do? What does a school attorney actually do? And pretty much using that same format, we're going to do that again today. What I've learned, though, is that this is also one way to present the same material to students. So I've actually, since the first teacher's law school, I've done a similar lesson to people who are being certified as superintendents, and they find it helpful. People who are seeking certification as principal, and then high school students who also love accessing the original documents. So we have 3 cases in your materials. Let's see, how do we forward this? Turning it on. The first case, all right, so basically this is an exercise on the First Amendment, and specifically the First Amendment rights of students. I was so excited to have Mary Beth Tinker here. I got to visit with her a little bit at the reception. I told her that I use her name in my practice at least once a week. We talk about her all the time. So it was really exciting to meet her, and also a little interesting to hear her perspective on her case. But the first case in your materials is an excerpt from the Tinker case, the Tinker versus Des Moines, arising obviously in the backdrop of the Vietnam War. All the public controversy and angst surrounding that conflict. And there she is as a 13-year-old student and her brother. It'll be more productive for you all to at least have looked through the materials. And so I'm going to give you 5 to 7 minutes to catch up on your homework. And then I'm going to have you form groups, and we're going to do a little exercise. Obviously, this is dense material. What I've noticed is it's readily accessible to secondary students as accessible to the students as it is to adults. I think a lot of times when we present this in a school setting, it's highly edited or summarized, but the language of these cases it's readable, it's accessible. What I tell the students is the folks on the Supreme Court write like surgeons. Every word is critical, it's meaningful, and I think it's accessible. So I know in your classrooms you do a lot of close reading of the text and using the text to support ideas. Frankly, that's all we do as lawyers and as litigators. A lot of that is close reading of text and then analyzing that and forming arguments from that textual basis. So we start with the Tinker case. Mary Beth talked about it from her perspective as a child. One of the most interesting things that she said yesterday is from her perspective, she was asked by the principal to remove her armband. She said she did and handed it over. In the case, they talk about, the record reflected that she was suspended from school. I'm thinking the reality is it was winter break, because this happened on the 16th of December. They probably went home from school. The interruption in their schedule was probably so small that she doesn't remember it now, but her parents did when they filed the suit. So the court in that case effectively said, and the takeaway was that if the speech of the student is not materially disruptive to the school activities or the school environment, that the school officials do not have a constitutional basis for restricting the student's speech, right? The next case in your materials involves the burning of a draft card. David O'Brien burned his draft card on the steps of the courthouse in Boston in front of several FBI agents who, after the demonstration and reading him his rights, explained that he had committed a federal crime, to which he admitted, and he said that the criminalization of his activity of burning his draft card was a violation of his rights to protest the Vietnam War. And the federal court said, if the government has a good reason, a legitimate reason for having a rule that does not on its face discriminate against speech. On its face, the law just said you can't destroy your draft card, that it is not an unconstitutional burden on expression. And the government can lawfully restrict Mr. O'Brien's non-right, his ability to protest the Vietnam War by burning his draft card. And then the last case in your materials is the Morse versus Frederick, which we all remember. The Olympic torch was passing through Juneau, Alaska, and a couple students got the idea to compose this brilliant sign, Bong Hits for Jesus, and when asked about it, they said, yeah, we just wanted to get on TV pretty much, which they did. The principals, seeing the sign, asked them to put it away. That did not reflect that it conflicted with the rules of the school that prohibit promotion of illegal drug use. And the students did not put it away. They were suspended from school for a short period of time, I think 10 days. And they proceeded to go to court and made it all the way up to the United States Supreme Court. The court said that the school district has a compelling interest in being concerned about student drug use, that the rule prohibiting student drug use was legitimate and a rational rule for the school district, and that they could limit students' speech about unlawful drug use. Okay, so in this case, and one of the reasons I threw it in there is because it has a good summary of the speech cases. It has the Tinker case, and then the 3 other limitations that have been recognized by the Supreme Court. So the Supreme Court has allowed schools to limit speech that is materially disruptive, that is perceived or readily perceived as school-sponsored speech, such as a school publication. The school can censor that speech lawfully. Speech that is lewd or offensive or obscene, and speech that advocates illegal drug use. So those are the 3 limitations that have been recognized over time by the Supreme Court to when a school may constitutionally impact students' speech or restrict or censor it. Okay? We're all there. Okay, now I'm going to give you a real-life example. This is when the phone rings in my office. Okay. Let's see if I can come up here. So the Board of Trustees of our hypothetical school district has been considering a dress code policy for many years. And in fact, our state permits a school district to actually adopt a uniform policy that all students have to wear the same uniform. School district really didn't want to go with a uniform. They wanted a dress code, but they wanted to be fairly restrictive. They're concerned about students wearing clothing to school that may be disruptive of the learning environment or distracting, shall I say. They want kids to be ready to enter the workforce. And the school board says, when you enter the workforce, you're going to have to look, dressed to the standards of the workplace. And so we want kids to get used to that. And then we also want students to think about college. So what are you going to do after high school? Think about colleges. Those are their 3 policy interests. After talking about this for a long time, they do adopt a strict form of dress code. It says no shorts. And if you wear a shirt, it can't have anything on it larger than a quarter. So if it has a logo, it has to be smaller than a quarter. But you can have 2 exceptions. One is school speech. So if it's Green Slopes High School cheerleading team. It's something about Green Slopes High School. That's an okay exception. And then we're going to allow anything that has the logo of an institution of higher education. So any college, because that gets the students thinking about higher ed. That's the rule. So our student, hypothetical student Peter Parker, comes to school with a t-shirt. And his t-shirt is printed with a message, "I'm with Hillary." Okay? When the principal stops him at the schoolhouse door and says, "Excuse me, Peter, you're out of dress code," he points to another student who's wearing a hook 'em horn shirt, which in Texas is the University of Texas logo. It's a orange longhorn cow, for those of you not familiar with them, Bevo. And he's saying, she's got Bevo and hook 'em horns on her shirt. What's wrong with "I'm with Hillary"? This is pure speech, political speech. I read Tinker. After being presented with the choice to change his shirt and go home or go back to class with a different shirt, he pulls on a plain shirt, goes to class. So there's been no interruption in his education. He doesn't miss a minute of school. But by the next day, his father's in federal district court asking for an injunction. Based on the cases that you have just read or that you've just learned about, how should this come out? I want you to get in groups of 7 to 10, and I want you to discuss. We're going to ask the juries to end their deliberations at this time, the courts to end their deliberations. Judge Rendell yesterday said that a lot of times when the cases get up to the appellate courts, it's because they're a puzzle. And this one is a puzzle, and it actually is a case that was decided in the Fifth Circuit and actually went up to the Supreme Court for petition for writ of certiorari. The plaintiff in this case, there he is, he was represented at the Supreme Court by a fellow you may have heard of. His name is Ted Cruz, which was kind of interesting. I just thought there's a lot of interesting twists in that. But anyways, his shirt, it was a while ago, obviously, isn't it? He had John Edwards for president. He did file suit. So tell me let me start with this group here. How did you all come out on our plaintiff's rights? Did you feel that the school should be enjoined?
Yeah, well, microphone.
We did. We felt that the school opened the door by allowing T-shirts with speech on them, and as my pal over here pointed out, they actually could have been allowing commercial speech with Trump University or other for-profit institutions. So by opening the door, then to say that students could not have T-shirts that had communicative political speech, that was not permissible. So that's
Okay.
where we came out. Anyone else?
So you were going to enjoin the school district's dress code, tell the school board that their reasons for adopting the dress code just didn't make sense?
Yeah, I mean, I don't think there's a...
Too awkward?
Yeah, I think that we were saying if they had kind of the traditional khakis and polo shirt with no logos or, no speech, that would have been acceptable, but by allowing speech on T-shirts, they put themselves in a different category.
All right.
So.
How about the next group back there? How'd you all come out on this puzzle?
Thank you. I think we were in agreement. We felt that the speech on the T-shirt was political speech and it wasn't disrupting the learning environment, so the students' rights were being violated. Similarly, we talked about if they're going to allow speech promoting support for a college, university, or football team, why would they draw the line at political speech, which in some ways is a higher level and higher quality speech?
In effect, you're saying that the school district's regulation is not reasonable? Is that kind of where, okay. Have you been elected to the school board?
Have I?
Yeah, okay, I'm just curious.
These folks are thinking you're not paying any attention.
I'm going in around the circle. It's not discriminatory, it's just, I feel like they're gonna get at least as much time. How about in the back? Who's gonna grant or deny this injunction?
Our group had a very spirited conversation that the consensus was because the logo on the T-shirt was essentially free speech, and the school board addressed the whole idea of the amount of free speech that would be allowed, that free speech could be allowed without regard necessarily to the amount of free speech on the shirt, and that the policy violated a student's right to participate in freedom of speech.
Okay. The school board is not faring well in this crowd. How about, all right, going around here to the next group?
Well, I was a dissenting opinion, I think, on this one.
Okay.
But I think the majority of the folks felt the same way, that it was a violation of speech. It was that the school board opened the door with the logo, and that the school board also had a obligation to let the student wear the T-shirt.
Write your dissent. You got the microphone.
Oh, the dissenting opinion, my thought was that I thought this could be materially disruptive, in a sense, because of the context of our political election, and wearing this particular T-shirt into class could be one that would disrupt school learning, and that the Supreme Court has traditionally come down on the side of students that making sure that their learning is not disrupted.
So you're going to be that assistant principal that in Tinker was worried about a disruption before it happened. Okay, great.
I think we talked a little bit about, with the message, and I think we looked at, we considered the school disruption issue, but I think at the end we thought about that, it's the student's rights to the free speech, and just because it might be a minority student or one student, doesn't mean that the majority's opinion is better than his. So I think his right to free speech is protected. We also talked about the Hook 'em Horns logo, and is that logo sort of conveys a different message about the school than maybe wearing a University of Texas logo, where you might think, oh, this is a great school that has great programs. That the Hook 'em Horns is sort of a football analogy and a football logo. So does that convey the message of higher education? Does it convey the message of a strong college football program? So that we consider that as well.
Well, as an alum of UT, I'd say that the hook 'em horns phrase transcends all civil law.
And the last group, last but not least. Oh, you got skipped? I'm sorry. No, you guys can go, and we'll come back around.
Well, yeah, we kind of were in two separate groups,
Okay.
but we were in some disagreement. I think that the argument was made, and we have different backgrounds. With some of us are private and some of us are public schools, but I think that the argument was made that the dress code wasn't necessarily substantially, limiting, but then some of us were in disagreement and felt like it was a content-based restriction, and therefore it really couldn't be defended.
Good. That is definitely his argument.
One thing we talked about is that we felt, this might be a different opinion than some others, but we felt that the dress code was installed, it was a reasonable dress code, and that the message, although it was very political, was still against dress code because it was larger than a quarter size. So we felt like, I mean, the whole part of it being political speech and being disruptive, we felt like it was moot in a way because it was a violation of dress code.
So the school board had a rational basis for adopting a dress code, and he's out of dress code.
Right.
All right.
I'm also in that group, and I want to say a few things too. The college aspect, you have religious schools that would show up, and that could be seen as promoting one religion over others as well, inadvertently. But students might read, Southern Methodist University versus something else and take that a certain way. We also talked about how I would send it back. So you can have a dress code, go back and fix the dress code because it doesn't seem to work that as well. And also kids that aren't going to college. No one is really thinking about, there are students that will not go to college or can't afford college, but yet you allow students around them to wear sweatshirts that say all these college names. That could be an interesting point of view.
Yeah, that is interesting. That did not come up in this particular case, but another form of discrimination, if you will. So I missed one, and then we have one more. Oh, sorry, go.
Sarah, I just want to add one thing that came up towards the end of our conversation in terms of the court considering the context in which this is all unfolding. It's not just necessarily the political climate at that time, because I'm sure that shirt was less provocative now than it would be back before the election of '08, but it depends on where you're at in the country too. Our colleague from South New Jersey reminded us that T-shirt, "I'm with Hillary," though probably not materially disruptive in lots of parts of the country, it would be in hers.
Exactly. And that's the whole discussion in Tinker about pure political speech and, the need to have a safe place for that. And we have Judge Young in the front row, and he said he would answer this question too. So, Mr. Microphone. How would Judge Young rule in this case?
What's that?
Will you grant Peter's
Well, wait a
injunction?
minute. Well, now she's changing the hypothetical. The first thing I would do is, I'm a trial judge. So that means I work for those higher judges. And in sort of the Holmes realist style, I'm trying to figure out how they're going to interpret it. I mean, she's got the citation there. So we're in the Fifth Circuit. And I know who those judges are. So I'm trying to figure out how they're going to do it. And the very first thing I'm going to do is stall. Now, her hypothetical was the next day the father comes in. I walked in and I didn't know I was going to be called on. But that's the hypothetical, and we have emergency cases. And so under our procedural rules, the first thing I'm going to say to the father's lawyer is, you don't want a preliminary injunction here. You want the trial on the merits. And I'm allowed to say that. And I'm going to give you the trial on the merits. When do you want to go to trial? That usually takes the wind out of their sails. Now, meantime, I'm talking to my law clerks. She gives you this hypothetical and says, form into your little groups and then decide this. No. Well, I'm saying, find me everything on this. And now, if I'm in the Fifth Circuit, I work for the Fifth Circuit. You have to understand that the circuits differ. I work in the First Circuit, actually, and I had a First Circuit judge say once when I cited, I made reference to a Ninth Circuit opinion, he looked at me and said, Ninth Circuit? Presumptively wrong. Well, so I've got to figure out the terrain, take a deep breath, but I'll answer your question because fools rush in. I tend, and the level of discussion is such a high level, my inclination is to come down on the side of free speech, the students' side. I try to be minimalist in the sense that if we could we try to settle it, maybe we can chivvy the school department into changing their codes or the like, and the injunction is only going to go forward. So unless we're trampling on this student's rights in the future, they don't need an injunction. Nobody needs an injunction. Why should courts get into it? And I want to be sensitive to that. School board's probably elected by the local community. And education is a local concern. Federal judge saying, well, you want to be careful about that. But based upon the facts we've been given, I tend to come down on the student's side. Now, if she's going to tell me I'd be reversed, another thing you find out is, I don't care.
Thank you, Your Honor. What the trial court actually did follow some of that sage reasoning, which is the first injunction came before her, Judge Lynn in Dallas, right about the last week of school. And so she let us go home and rewrite our code of conduct and come back next year if we couldn't come to an agreement. The code of conduct, or the dress code, was revamped. It still eliminated political speech, such as the T-shirt our plaintiff is wearing in this image, but they did tighten up a little on the hook 'em horns type messages. But it was effectively similar when it went up through the circuits. And the argument was, is this a viewpoint discrimination, or is it a dress code that is based on a legitimate policy consideration from the school board's perspective, and should the federal courts get involved? And the answer, the Fifth Circuit said no, but it was a close enough case that there were a lot of interested parties filing amicus briefs and asking the Supreme Court to take this up. But I was saying, you know, this material is really accessible to students. I was riding on the plane back from the Fifth Circuit, and my seatmate was a little 15-year-old boy. You could tell he was a handful. And he was being sent to military school in Harlingen. I think, do you all have a military school down there? For the summer by his family. So he kind of looks at me, gives me a evil eye, and says, how come you're so dressed up? Well, are you working? Yeah, I was working today. What'd you do? Well, I went to court. Do you always have to dress up for court? Yeah, pretty much. What was it about? Well, it's about a student wearing a T-shirt that said John Edwards for president, for, you know, and whether he could wear that to school. And I said, don't you think that's kind of cool? First, like, that's dumb. And then, you know, that is kind of cool, that any child with an issue like this, with an armband or with a T-shirt, can get the serious attention of some very serious judges that really want to dig in and figure out what their rights are. And he's like, yeah, that is a little bit cool. And then off he went to military school. I don't know if he gained anything from that or not. But effectively, the court said, this isn't really viewpoint discrimination, where we're going to subject the school district's rules to strict scrutiny, but it's a time, place, and manner regulation on speech, and we're just going to say that there has to be some rational basis. Even if it's difficult for us to understand the school board's rationale, they did have a rational basis, and that's how they came out on that. All right, scenario 2 in this one, and we're going to have to go really quick. Election to the Woodland Township dance team is a very coveted honor, very competitive team. Maya Jones is a freshman, and she is the first freshman in recent memory and the first African-American student in recent memory who's made the dance team. At the homecoming football game, the high school choir gave a rousing rendition of the national anthem, and the dance team performed next, and they did a stupendous job. After the game, a citizen brought a photograph to the principal, and the citizen was mad. You could see in the photograph that Maya is seated and not standing for the national anthem. When Maya is asked about this, she said, yes, I was engaging in silent, non-disruptive, symbolic speech. I was communicating my objections to state-sponsored violence against African Americans. So after the principal consulted the dance team's organizational documents and rules, it reveals the policy says it's students to the dance team must reflect the highest level of decorum at all times and model exemplary behavior. And the reason for this rule is because the dance team members are looked upon with honor, and they are representative of the high school at large. So Maya tells the principal, I'm going to continue to sit. I have a right to express myself on this matter of public concern. But the team is about to be performing a dance number during the singing of the national anthem, and Maya says, I'm not going to do it. I'm going to sit. So they kick her off the team. Okay, Maya wants an injunction, keeping her on the team, and y'all have 10 minutes to figure that one out.
Process for students to vote. I mean, to be involved. It's not, I would be more disruptive if the church says, whatever you do, don't vote for anybody.
So, has anyone reached a decision that they want to talk about instead of going around? Any group forming a consensus? Not sure yet? Have you formed a consensus yet? Okay, so let's hear from this group.
Well, our questions came from the fact about who the heck dances during the national anthem. And also, was that part of the performance when she applied for the team, or have they created this event in order to exclude one member of the team, much like if they moved a performance to a religious holiday simply to exclude one member of a team who had a particular religious affiliation?
Certainly is suspect, isn't it?
It's a suspect issue. And if performance in all events were part of the rules, not this decorum, but performance in all events of the team were a requirement of the team, then her refusal to perform for an event of the team would be grounds for dismissal. But if that was not part of a normal performance, and we couldn't think of any time when it would be, then it appears that they're just restricting her speech unconstitutionally.
I'm going to jump around. I might not reach everyone, but how about, I know I missed a group in the back before. Make sure we get them.
Yeah, and actually, can we go back? One of our questions was the legality of any school dress code.
It's legal.
Okay, because just that was one of our, with the last one, we were like, well, if it can constantly be challenged in that forum, then we were just wondering if that's...
Do we allow midriff shirts in your school?
We're not going to talk about my school.
Okay. School boards can adopt reasonable dress codes, and in the Fifth Circuit, they can adopt a uniform as well.
Okay, yeah, just...
But what are we going to do with Maya?
Yeah, what are we going to do with Maya? Who's going to...
I was also reminded that I'm from Portland, as I said my opinion on this one, where when I looked at the subjective nature of must reflect the highest level of decorum and at all times model exemplary behavior, I think standing up for what you believe in is at all times model exemplary behavior. And that if the system in place is to be super oppressive to this one student because of what she believes in, then the system is wrong, and thus it should be going up to that higher level. And that's...
I will tell you, in practice, there are many, many similar rules of participation for things like dance team, cheerleading, in my experience in our state. And you're right, it's very problematic. It's a very broad, non-specific policy, and its enforcement can be problematic. How about one more in the back here?
Really going to make me talk about this. We went back and forth because our question is where did this happen? Because in Florida, you have to stand. You don't have to say it, but you have to stand. So if it's a school event and it's a mandate, then I would say that.
So Florida law requires you to stand during the singing of the national anthem. Great. Okay.
No, that's the pledge. Sorry, I'm wrong.
The pledge.
That's
you have
pledge.
to stand, but you don't have to recite.
So then that makes absolutely no sense.
It raises interesting issues when that collides with speech.
Right. But one
is
thing,
there a compelling government or even a rational governmental interest in enforcing children to stand?
Right. Well, the other thing we talked
what?
about is if this is an after hours thing, is it a right that she
It is not a right to be on the dance team.
Right. So that
It's
was
a
one of the
privilege.
things we discussed.
Can we restrict children's constitutional rights when they're participating in school-sponsored but not mandatory activities? Does that make a difference?
No, but her, I guess, her being on the team or not is a.
It's a privilege. Get with the program. Follow. Okay. Okay. I think one more. I have permission to go over, but I don't want to go over. So just one more.
I think one of the
Someone
things
on this side.
One of the things that struck me about this case is that I see it as there's precedent for it. So I'm thinking about West Virginia Board of Education versus Barnett, and one of the things that was interesting about that is that they overturned a previous decision where you had students that refused to stand up for religious reasons, but the way that they overturned it wasn't going back to the First Amendment, religious clause. Rather, they said it was compelling speech. So the school board of the school cannot compel you to stand up because that's compelling you to do something that goes against your action. So I see this as the dance coach is getting a supplement from the school system. So whether there's rules or there's a privilege, it's still part of the school and it's still part of the school body. Therefore, she is violating that student's right to refuse to stand up.
Yeah, so I don't know how this one comes out. This question actually passed my desk twice in the last week, and so I was hoping you can solve it for me. In different permutations, but basically the same issue. I think the way it comes out, and I think the way that I'm going to steer my school districts is to the extent that you are interfering with the activity as a whole. In other words, if there is a dance number and you're sitting out, you probably, as a school official, have a rational basis for restricting students' speech in that context. Just like in biology class, you can't stand up and recite the Pledge of Allegiance in the middle of class, right? That's within the proper role of the school district. What's going to be difficult about this is the school district really creating a conflict where there didn't need to be one, and I think a couple of you were sensitive to that. We know that these rules can be created on the fly, if you will, and we wonder if the dance number was changed. I've never seen anyone dance during the national anthem either, but so these are the kinds of issues that we deal with in schools every day. I know you all confront these. This is what makes my job so fun, and this is why I just love working for schools and educators. And again, I appreciate you inviting me here. I appreciate the National Constitution Society for making this such a wonderful opportunity and being so gracious, and thank you very much.